Hello everyone and welcome to the first of our video tutorials on criminal process. In this tutorial we'll be looking at the criminal categories of offence and an outline of procedure to trial and the criminal courts. Let's start off then by looking at the criminal court hierarchy, which we're already familiar with. We've got the Magistrates' Court at the bottom, the Crown Court here, the Court of Appeal and the Supreme Court at the top. Now remember, these two courts at the bottom are courts of first instance, which means that they're hearing cases for the very first time, whereas the Court of Appeal and the Supreme Court are our appellate courts, which means that they're appeal courts and they only hear appeals. So what we're looking at today is how do we decide in a criminal case whether a criminal offence is going to be heard in the magistrates or is it going to be heard in the Crown? In order to decide where a criminal case is going to be heard, we go to something called procedure to trial and mode of trial, where we're looking at where the case is going to be heard. Now, every single criminal offence can be categorised into one of three categories, which you can see down this side here. So we've got summary offences, triable either way offences, and indictable offences. Summary are the least serious types of offence, and because they are the least serious, they're going to be heard in the lowest court in the hierarchy, in the Magistrates' Court. And I've given you some examples here of the types of offences that would fall into this category: assault, battery, driving without insurance. Triable either way offences are in-betweeny offences, for want of a better word. They're ones that are sort of in the middle in terms of seriousness. And because they're in the middle, they can be heard in either the magistrates or the Crown. And notice that's where they get the name, triable either way, meaning they can be tried either in the magistrates or in the Crown. And offences that fall into this category include Section 47 ABH, Section 20 GBH, and theft. And if you think about theft as an example of why it's triable either way, theft can vary massively in seriousness. If I take my friend's pen intending to never give it back, that could be theft. Whereas if I steal something of very high value, £150,000 maybe, that's still theft. But obviously we know the seriousness is different. So these crimes vary in seriousness, so they can be heard in either court. Indictable offences are the most serious offences, and because they are the most serious, they're going to be heard in the Crown Court. And examples here include Section 18 GBH, murder, manslaughter and rape. So once you know what type of crime you've got, you work out which category it's in, and that will tell you which court we then hear the case in. Now obviously the issue we've got is with triable either way, because we're going to have to make a decision at that point: is it magistrates or is it Crown? So for all summary or least serious offences, it's very straightforward. We start with an early administrative hearing, or an EAH, and that will be in the Magistrates' Court, and they initially decide on bail. Do they get funding? They'll look at pre-sentence reports. And your defendant's got two options. He can plead guilty, in which case he'll be sentenced at the magistrates, or he can plead not guilty, and then we go to trial at the magistrates because it's a summary offence. So that's nice and straightforward. Triable either way offences, it's a more complicated procedure because we know they can be heard in either the magistrates or the Crown. The first hearing you have in a triable either way case is what we call a plea and case management hearing, or a PCMH. And what happens here is that the defendant goes to the Magistrates' Court and enters his plea. If he pleads guilty, then we have sentencing at the Magistrates' Court, or they can send to the Crown Court for sentencing. If, however, they plead not guilty, this is where it gets more complicated for a triable either way, we then go to mode of trial. And that's to work out, okay, they're pleading not guilty, so we need to decide, is it magistrates or Crown? And the defendant can choose to go to magistrates or the Crown Court. Okay. Advantages of being in the magistrates court is that they have less sentencing powers, but remember they can pass to the Crown Court for sentencing anyway, or the defendant may opt to have trial by jury in the Crown Court. If we have a look at the procedure for indictable offences then, it starts with an early administrative hearing at the Magistrates' Court, but the Crime and Disorder Act says magistrates must then immediately send to the Crown Court using their committal proceedings. So because it's indictable, the magistrates have no power to hear it. So if the defendant pleads guilty, they will be sentenced at the Crown. If they plead not guilty, they will go to jury trial at the Crown Court. So that's just a whistle-stop tour of the procedure for the 3 different types of offences. Remember that in both the Magistrates' Court and the Crown Court, because this is a criminal trial, the burden of proof, meaning who has to prove it, is on the prosecution, because remember you're innocent until proven guilty, and the prosecution have to prove beyond reasonable doubt that the defendant is guilty. And when we looked at the civil system, we saw that there are civil procedure rules that were created by Wolff. Similarly, in the criminal courts, we have criminal procedure rules, which set out how criminal cases should be dealt with. And I've got a copy of the rules here for you. You don't have to memorise all these, but I just think it's a good idea to have an overview of them. So the criminal procedure rules say that all criminal cases should be dealt with justly, meaning fairly, and they've got some of the key principles that are important in ensuring that cases are dealt with justly. For example, it's important we acquit the innocent and convict the guilty. That we need to recognise the rights of the defendant, particularly under Article 6. Article 6 of the European Convention on Human Rights is the right to a fair trial. So those are criminal procedure rules. We're going to consider now the role of the courts here, and the role of the courts in both the magistrates and the Crown, if the defendants plead guilty, is just a sentence. So remember, sometimes your defendant will plead guilty straight away. They're just going to issue a sentence there. Obviously, we don't need a trial. If they plead not guilty, the court has to firstly try the case, and then if they're found guilty, sentence. And just to give you an overview then, magistrates' courts, there's about 430 of them in England and Wales, and they are local courts, and there'll be one in almost every town. Although the magistrates from Widnes actually closed down. So the nearest magistrates court to us is Liverpool Crown. And cases heard there will be heard by magistrates who might be district judges or lay magistrates. And we look at lay magistrates in a later topic. I've got a nice little clip of the role of the magistrates court. If you click on this link, you'll be able to follow that. And that's really nice to give you a view of the role of the magistrates court. They have a hugely important role. They deal with 98% of our criminal cases. They're issuing arrest and search warrants. They're dealing with bail, as well as sending indictable cases to the Crown, dealing with all of our summary offences, dealing with most of our triable either way offences, and dealing with young offenders in the youth court. There will be a youth court in every magistrates court, and they are going to deal with our young offenders aged 10 to 17. And again, I've got a little clip that you can watch specifically on the youth courts. So I'm going to skim on over onto the Crown Court now. So just so you're aware of the role of the Crown Court, again, there's a little video clip on the PowerPoint, which gives a nice overview of what the Crown Court does. But in a nutshell, it's got 4 basic duties. It's going to try all of our serious indictable criminal offences, such as murder, rape and robbery. If we don't need a trial because they pleaded guilty, then the judge is going to sentence. They're also going to try triable either way offences, which we've decided are going to be tried on indictment. So that's where the defendant has chosen to have trial in the Crown Court. They also deal with appeals from the Magistrates' Court, because remember, the Crown is above the magistrates in the hierarchy. And they will also sentence some defendants that were tried in the Magistrates' Court, where the magistrates feel they don't have enough sentencing power to issue an appropriate sentence. And there's a little diagram here which just shows you the layout of the Crown Court, but you've probably seen it in films. You've got the judge here, the court clerk, you've got your barristers, your witnesses for the prosecution, your witnesses for the defence, the defendant here in the dock, the jury over here. Witnesses will come to the witness box. You can have press and the public in the gallery here, and an usher who will help to guide the proceedings. The Court of Appeal Criminal Division is the next court up in the hierarchy, and it's in the Royal Courts of Justice in London, and it deals exclusively with appeals from the Crown Court. And it's staffed by our Lord Justices of Appeal. The head is the Lord Chief Justice. And the criminal procedure rules from 2017 have made some changes to the previous criminal procedure rules, so just to be aware of that. If we go to the Supreme Court, then we know that that's the top court in our hierarchy. And again, like with some of the others, I've found you a nice little video clip. There's a 9-minute video there which shows you the inside of the Supreme Court. It's quite an interesting one. Definitely watch that to help give you a bit of insight into the Supreme. So the Supreme Court, we know, was created thanks to the Constitutional Reform Act 2005, and it is the final court of appeal for all UK criminal cases from England, Wales and Northern Ireland. But remember that this court only hears appeals of general public importance. So it's hearing on average 50 to 60 cases per year. And they have to be cases that are important not just to an individual defendant, but to the general public. And you have to have leave to appeal. And there's a little diagram here which shows you our court hierarchy. And it also shows you appeals. So we can appeal from the Magistrates' Court up to the Crown Court, and that's the usual route of appeal. So that's number one. You can also appeal from the Magistrates' Court up to the High Court, and that's labelled as appeal number 2, and that's a case-stated appeal. So this is the normal appeal, but you can have a case-stated appeal where it's just on a point of law. So the magistrates are just referring a point of law to the High Court. And the High Court, you can see, can leapfrog to the Supreme Court. But our usual appeal routes are from the magistrates to the Crown, to the Court of Appeal, to the Supreme. And you've got detail in your booklet about that, how those appeals take place. So that's just a very quick overview of our 3 categories of criminal offence: the criminal courts, what their roles are, and the possible appeals. Do watch the video clips that are hyperlinked in the PowerPoint, which you can get off Solar, because they'll help add to your notes as well. And do read all the detail on these appeals, which is in your booklet.